And everything is fixing up in India. So in a place like that, it's like a double-edged sword now. Digital marketing, digital business strategy, digital platforms, everything. Person to person, we are not able to handle. Then how something which is getting operated beyond the borders and how we are going to deal with it. That's a question that cannot be answered in a panel that I but still, thank you, Gautam, that you put that dilemma that we are facing. That was a very quick, crisp, and but packed with insights from their practical experience. Like perfectly drafted affidavit, I can say, if I'm saying it from your area of profession. Thank you. And Shruti, we actually stopped at the evolving digital data governance that you were talking about, the balancing all these legal framework with the innovations. The digital data governance is an inevitable part of the business regulatory landscape nowadays. The coming decade, we hope that will define India's trajectory of data protection, maybe AI regulation and digital innovation. But the challenge lies in crafting a coherent governance model that safeguards right while enabling technological growth. Both we cannot do away with, right? So my question is, as India moves forward, comprehensive data and AI governance, how can India's legal and institutional frameworks move from data protection towards a broader model of data governance, ensuring fairness, transparency, and accountability without constraining innovation? The exactly same thing, that the balance that you were talking about. What are the perspectives that you have got? What are the ideas? Because you are the one who's actually doing a lot of research in that area. You're facing that. I know that it's not that easy to find out that balance that middle ground, but some try may be happening.
Great question, Dr. Nisha. So first, let's understand the environment in which we are operating. We are creating governance models for technologies that do not yet exist. We are to manage harms that we do not have any, full inkling of, and that are changing faster than the algorithms. That's the whole lay of the land. And clearly, it is a journey from data protection to data governance, because ultimately you have to have models that bring in the convergence that must come between data protection, technology laws, AI governance, and evolving technologies, if I may say so. So in that context, I think one of the fundamental things we must do is that ultimately we will have to look at a risk proportionate approach when we are looking at creating broad-based governance models. One size doesn't fit all, will never fit all. And therefore, we have to look at how do I evaluate, quantify, and determine the risk that a particular business does, and therefore create a tiered approach about how the compliance and governance roadmaps for those organizations must have. Secondly, India is actually already moving, towards the national data governance frameworks, which look at non-personal data and data protection. So a dual approach as to how do you bring in not only protection for an individual's privacy rights, but how do you also foster business and growth through a more sustained and responsible usage of non-personal data. So therefore, a convergence of both those frameworks, the legislation and the national data governance, framework approach, will bring in some kind of how do I say this, but will bring in some kind of homogenization of what a larger data governance model should look like. Third and most important thing, I think, is that we will have to, in order to stay relevant and be, doing the right thing in the right way, we will have to align with global standards. Because without that, you cannot have, a larger relevant existence in the world out there. So for that, we will have to look at, how are we creating the structure around data portability that GDPR provides. And I think we are mirroring it in some ways in the consent manager framework that India is bringing along. And so it has to be, keep it indigenous, but you've got to keep it relevant from where the industry is also the world is moving towards. Three principles on which the governance model should be based on: easy access, consent. How am I managing consent? Is it clear? Is it for a specific purpose? And how am I enabling portability? If I want to kind of go from one user to another, then how do I kind of forward that? I think light touch regulations, regulatory sandbox will be some of the key factors of how governance and innovation has been moving forward. And also, in order to converge all of this, should there be an independent oversight body? Now, obviously, how independent are the oversight bodies will also be something that we will have to work on and put that together. So those would be some of the basic fundamental framework I could think of between our journey from data protection.
Are we in that line?
We are pretty much moving there. Like I spoke about the data protection, the national data governance framework, the consent manager framework, the regulatory sandboxes, the free AI RBI framework that's expected to come by 2026, which will look at credit algorithms, report access also from the perspective of creating sandboxes for financial. So there's several ones, social media intermediaries, rules, etc. So there are things that are moving in that direction, but there's a lot that needs to be done.
Yeah, thank you, Shruti, that happy to hear that we are in that line, because data governance is every layman, in layman's perspective, we are all afraid of. That is what are they going to do with our data? The governance, in the name of governance, whether we lose our privacy questions, that is everything. Any lawyer from right to privacy comes, oh, we are in trouble, we are going to suffer out of this governance. I mean, we don't have any other option. We can't go back to 10 years back or 20 years back, maybe 100 years back, that this is the only way out. That how the governance, how the compliance, how the protection, all these things can be in line, balancing with all the personal things. Once we are actually inviting a devil to our home, we should know how to treat it and how to deal with the devil. Otherwise, that we will may lose our home at all. And Gautam, since you have got a standing practice in with Competition Commission since 2008, that's why this question: how do you assess the existing competition law and the structure that in the perspective of digital governance and digital regulation?
So, some of the problems are applicable to both digital and the non-digital world. And then, like I said, we borrowed the concept from Europe and we just copied it. What we did not figure out was that Europe, a lot of countries are civil law jurisdictions. India is a common law jurisdiction. So they are fundamentally different concepts, both in terms of substantive law and in terms of procedural law. So if you look at substantive law, for instance, if I'm a non-dominant player, I'm a distributor. I go to a dominant player and say, look, I want a contract which is one-sided. And subsequently, I get irritated and go to the commission and say, look, here's a dominant player who's abusing its dominance. Commission will still say, yes, the dominant player has abused his dominance. That is something which is very unusual in Indian context. Even in terms of, and this happened in case of Maruti, which was penalized some 200 crores. Maruti was told by distributors that there's too much of competition happening at the distribution level. We are all undercutting each other. So why don't you dictate the discounts to be offered? So Maruti came up with a discount policy saying, look, this is the maximum discount that you can offer. Somehow this issue landed up at commission. Maruti kept arguing that I did not do this discount policy. The distributors who said, oh, please apply a discount policy. Based on that, I developed a discount policy. Why are you coming after me? She said, nothing doing. You are the dominant player. You have a special responsibility. We'll penalize you. So that's Maruti with 200 crores of penalty, not realizing what are its obligations as a big guy in the market. Procedurally, so in a normal court proceedings, you see there is a judge sitting there. There is a prosecutor who cross-examines the witness or examines the witness, and there is a defense counsel who is present there to interrupt if the process of evidence under the Evidence Act is not taken care of. In this case, when the DG investigates, the investigation arm of the commission is called the DG. When he is investigating, he examines the witness himself. As on date, the defense counsel is asked to sit outside the room. And this is a statement on oath, which will be used against the witness. So those are procedural, differences between the normal existing ecosystem and what we have borrowed from Europe, which are creating problems. So when these issues land up in a court of law, in a high court or Supreme Court, a judge who has been trained in the Indian legal system, Indian legal processes for the last 30, 40 years, suddenly says, what is this happening? Ye kya ho raha hai? There's something very abnormal about this. And this is what happened right in the beginning. There was all the proceedings of CCI were getting stayed because of these procedural differences. Thankfully, that has stopped. Courts are much more careful about suspending an investigation. They say, okay, we'll hear the issue, but let the investigation continue. That's a big difference. We have evolved a little slowly. CCI has now started looking at economic evidence in a much more substantial way. You see that in their judgments, they use economic tools, they use economic analysis, they look at economic evidence to come to a conclusion. So that's reflective of their growing confidence. Penalty amounts are increasing. They're willing to go ahead if they see there is a clear case of violation, they impose penalty. Cartel penalties are significant. They look at your global turnover, and the penalties can be 3 times your profit, or 10% of your turnover for the number of years for which the conduct has continued. So it's for, let's say, 5 years, cartel conduct has taken place, the penalties just zoom up. I talked about the disconnect between High Court and Commission. The same disconnect was in the appellate court. You have the competition appellate court now, NCLAT, where again it's a former Supreme Court judge is sitting. So this tussle used to happen where CCI says, this is how I am going to approach this issue. And then you have a judge sitting in competition appellate. This is nonsense. This is not how we operate in India. And they'll throw out those cases. So those things were happening. Thankfully, it has slowed down. Are we ready for the challenges of the digital world? No, not on date. As on date, neither are we ready for it, nor are any other competition authorities. We are all struggling with this concept. Let me give you an example. Fitbit was acquired in Europe and in UK as well. So they approached the competition authority for the transaction. The UK competition authority said, okay, very good, you're acquiring it, but you can't use the data of Fitbit for other markets. Now I will, there's a contradistinction. When you come to India, you had a WhatsApp case where CCI told WhatsApp that you can't share data with your parent company Meta. NCLAT has just thrown out that order. and said, okay, sharing is permitted. Yes, they retained the penalty, but they said, fair enough, you can share the data. And if I look at it from an economist's perspective, it is efficient for me to share that data with my group company. If I'm getting data for my consumers and getting to know their behavior, I can tell my other companies, hey, look, this guy wants maybe some potential, some particular kind of food. He's into gymming and all. He wants to consume certain particular kind of food. Let's offer him that food. It makes efficiency. It's good for efficiency. But from the other perspective, you're coming and saying like, okay, since you have the data, but your competitor doesn't have the data, he's at a disadvantage. So it's efficiency versus competitors. How do you balance this? It's something that we still need to figure out. Law is still evolving. Another problem is of trained manpower at the commission. They've always had shortage of manpower. Forget about training. Okay, they've always shortage of manpower. Now there's a requirement of adequately training them to address the new concerns. CCI has looked at the civil aviation industry, again saying, look, there's an algorithmic collusion happening. So, and I've been involved in some of those matters. What's happening is, you must have all visited Make My Trip. Make My Trip has all the prices of all the competitors. So my clients told me, look, boss, what we tell our guys and our systems is, look at Make My Trip, our prices should be on the first page of Make My Trip. Because nobody goes to the second page to buy a flight on Make My Trip. So it has to be on the first page. Now I know the prices of my competitors, I am trying to match them. So there'll be a parallel pricing that will be happening in the market. If the prices of my competitor goes up, I will also increase my prices. If the prices of my competitors drop down, I will also drop my prices. I am reacting to the market. But when an outsider looks at it, they say, hey, look, there's something wrong. I think they're coordinating their prices. Maybe they're talking to each other. But there are softwares dedicated to just observing the Make My Trip first page. They're not violating the law. At least intentionally, they're not violating the law. So these are the kind of questions which are coming up. They need to be addressed. Courts and the commission need to talk more often to each other. They need to tell each other about their concerns. Commission needs to talk about its issues, and court needs to talk about procedures and say, look, there is a problem. This may not survive. What procedure you're talking? So that conversation is required, which is not taking place. And if they start doing it, maybe they are prepared for this new evolving world.
So, yeah, once I'm hearing you, I mean, not exactly that comes under this talk and the panel, but still all the students who are sitting over here, I don't know whether you have heard him, that there is a gap for being an expert, that people, that manpower is missing over there, that trained people are not there, there is a gap over there, that each and every student who is sitting over here, if he is actually trying to find it out that, okay, this area is an area of expertise that I can earn, that I can be an expert in that area, and I can work for that, I can do more research into that area. Whenever people are telling that there are hundreds, I mean thousands of law schools and people are coming out of it and expertise is still missing. So that is one point that as a teacher I picked it up from the whole discussion that you were doing. Thank you Gautam for putting it across over here for these people, because every day once I'm talking with the students, they do have a feeling that, oh, in law what we are going to do, that we don't have nothing much to do. We do have things to do more, comparing with a decade back or 22 decades back, whatever we used to do, we have got more to do. That is that too in an area in which these people do have an interest. That as that Shruti was talking once we were working, that is all these Gen Zs who is too much into technology, that older generation needs your support for bringing things in line and that in place, that all the balance that they need, that what have that we all don't have. So all these aligning together with the younger generation's expertise in those areas, with the wisdom that that experts do have with ages, once we are bringing it together, that kind of solution and the balance that we are talking about. I think we are actually waiting for the other panelists. That's why I'm looking whether if she's coming. I do have some questions to her too. Shruti, I know that you are an expert in technology law, that is technology law and the policies and the in the government. So there is always a problem. That's whenever we are talking about this balance and the control, that legal landscape, regulatory landscape, cross-border data is a problem. Data is not Indian, it's not American. We cannot, that doesn't have any nationality. It crosses the borders. Once it crosses the border, all the laws stuck there. No, that is we cannot reach beyond that territory. That our territorial age-old concept that creates a lot of problem to transcend this law beyond our territory. That itself is a problem to make the cross-border data untouchable most of the time. Related to that, if problems arises, we are still at the point where we have begun maybe 10 years back, 20 years back. That's what feeling that as an expert, what is your say in it?
So thank you, Anisha. Couple of things. First, to your point around there's enough and plenty happening in the world for lawyers to contribute to and budding lawyers to contribute to. So I just wanted to build on that for you. For the simple reason there are no longer, there's convergence there as well. There are no pure play legal jobs out there. You need analytics, you need lawyers for data analytics, as you need for competition commission experts. So, there's a bunch of convergence of and mingling of two expertise happening out there. So the world's getting more interesting and exciting when you are doing law versus when I started out, doing law. So, so just that, and I think this question of yours, Dr. Nisha, has a lot of common threads from what Gautam was saying. Just firstly, so three common pieces. One is how nimble-footed we are in our creating our legislation, regulation, and governance framework. Clearly, there's. Let's wait to welcome her.
My extreme apologies to all ladies. You can that is okay. It is understandable now because the chat now is not somewhere near to the 20 minutes. Extreme apologies to all. Let's welcome her. To have amongst us one of the distinguished panelists, Advocate Madhumita Bandarji, Advocate on Record, Supreme Court of India. Now please accept as a token of love and respect from the GE Goenka University. Thank you.
We are very sorry that we will have to take it forward because people will have to leave by 10:30. They do have all the. It's a working day. We cannot. Shruti, you can continue with whatever you were talking about.
Thank you, and welcome. We were looking forward to meeting with you, and I'm glad we met. So the common threads with what Gautam was creating was one, lack of expertise that he spoke about. Two, we're not exactly as nimble-footed as we can be, and therefore it's leading to a lot of lack of clarity, which has been my thread from the first question. And if I may say so, opacity at a lot of times in terms of what to create. And then while to my point that we have to create global relevance, but at the same time, the indigenization of it, like Gautam alluded to, and how to kind of be adapted to ourselves needs to be taken forward. So I think one of the key challenges in that area is, the opacity that we are creating out there in terms of how cross-border data flows must be handled. Now, the Data Protection Act came out with, a list which said that all transfers are permissible, except for transfers to restricted countries and what they so-called a red list. And nothing else got specified. So when I say lack of clarity is like, you need to say more for that. And with the DPDP rules coming out, Rule 12.4 doesn't help further. It just kind of says that, there will be a further need to localize data. And again, doesn't say beyond what that means. So clearly, one of the principles that we could borrow from EU and GDPR, their relevant law, is the equivalent standards that must exist. And those are, those are very, very transparently based on the rule of law, human rights, limited state supervision, all of those fundamental things that we could perhaps look at and borrow from. And because without equivalent standards, the data transfers, the data flows, and with state supervision, restrictive state supervision, there will be a lot of push and pull that we will have to deal with, and will then cause a lot of churn and a lot of anxiety and confusion where it comes to the way that the regulations should emerge and the governance models and frameworks should emerge around this. So I think a couple of things that we could perhaps consider to do in that area is, one, definitely get clarity in our legislations and regulations around what would be fair, fundamental data transfer standards that will work for us. One of the things would be that we will have to have a lighter state intervention and supervision around that, and then have what could be the alternate transfer mechanisms that we could bring by, contractual clauses like the SCCs of the GDPR. You have the standard contractual clauses, so something around the same lines that we could work around, and minimum digital data governance frameworks. The G20 summit did, a ministerial meeting did look towards that, and also certification mechanisms, in something that is more easier to comprehend, easier to interpret, easier to follow. So the ministerial meeting, Gautam, in fact, was a great precursor to the WhatsApp outcome that NCLAT finally gave us, which is, okay, give them the penalty, but at least allow that data transfer to happen, because you cannot restrict data transfer. For very, very, pardon my saying so, lopsided reasons. So yeah, I think, for the students out here, that's where you can see where technology, AI, data protection, governance, all of that is converging with competition, so that you make sense of why this conversation has someone who doesn't know nothing about competition law and sitting with a competition law expert, and therefore creating that conversation for you. So I hope that helps.
Thank you, Shruti. And I was about to ask the question regarding this intersection. Before that, let me introduce our panelist, Madhumita Bhattacharjee. She is a advocate on record in Supreme Court with a distinguished practice in regulatory and compliance systems, and she is having a lot of experience that actually are very relevant in this conversation. And I believe that the procedural fairness and responsible competition, all these things will have to come from a lawyer who is actually giving advice to her clients. That is the way how, once we were talking about learning good practices, good governance and all on the part of the companies, and I was talking about unlearning the things that they have already learned. it has got, lawyer has got a role into it that I do believe. In your opening reflections, we do expect that we will get some points or some strategy that we are expecting it from you, ma'am. His mic is there.
Yeah, good morning everyone, and again my apologies for the delay because I understand if it's item 2 or 3 and you reach by 10:35 and your matter is dismissed. So for me time is really important, but of course I'm not traveling regularly to Gurgaon, so I really didn't anticipate. So our travel area is from South Delhi to Supreme Court, High Court and back, so I really couldn't anticipate, and to be on time is really important, I must say, for a litigation lawyer mainly, because no judges wait these days, no Passovers even. They say, no, your counsel should be here. Anyways, so coming back to the topic, well, as a advisory counsel or the advisory role that we play as a practicing lawyers, when the clients come to us, I have always seen an attitude that to spend on compliances or to take those advisory roles, they find it quite an unproductive expenditure. Say, for example, say startups, they always feel, well, compliances we'll see later. First, let us focus on growth. I mean, growth is all right, but then this attitude needs to change. So I always say this, that see, we now the lawyers should be the part of the governance, and they should not be like post crisis firefighters sort of. Once you have landed in some problem and then you come to the lawyer and say. So to all those corporate clients that I have, I always advise them that whatever you do, please take our advice, because you may find that there it involves certain expenditure, but one thing I can vouch for is that those expenditures are much lesser. I mean, the regulated pre-compliance expenditure is much lesser than the litigation part or when you are in deep trouble. So I would say that the lawyer should play a very proactive role, give the clients a very fair picture. See, this is the pros and this is the cons, and where today you stand. Even for replying to a show cause notice or any sort of notices, it's not that you just get it done in a way and then just send it like that in a very casual way, because that gives you the very basis of the case. I mean, it starts from there, because the court would say that, okay, show us your reply. Tell us, where did you plead this? Where did you say this? You know, because I remember in one of my cases before Justice Rajiv Sahai Anglo, it was an appeal, and I didn't do much of district court practice. I didn't have that opportunity, but at times I feel I should have done. So the client came to me in High Court, and when I drafted the petition and started arguing, Justice Rajiv Sahai Anglo says, Mrs. Bhattacharjee, by looking at the petition, I feel that Nanavati has become wiser after he met his lawyer. so whatever you say, you haven't taken all these points before the court below. So I'm sorry, I can't help you, although you have done it pretty well. So I was a young lawyer that time, and it was quite encouraging thing. But I really learned that you have to make the basis of the case at the original site jurisdiction, the first court. So you need to tell your clients that these compliances are very important. Once you receive a notice or any such thing while you reply to them, you must be very meticulous, very categorical, answering each and every allegations. And those, it should not be like it, your what should I say? Your attitude should not be to please the clients and what they want to hear from you. It's up to everything is okay. It's not like that. You should make them compliance ready, and tell them that compliance is also part of your everyday job. You can't escape from this, and only then there will be growth. Because if you are entangled into litigation and you are entangled into this, you cannot really focus on the growth or the other part of it. So these days I always tell, but I have seen this with the startups basically. they say, "Oh, ma'am, we'll do that later." I mean, abhi to kuch nahi hai na, so we'll do that later. So that unproductive expenditure is not an unproductive expenditure. Those things should be explained to the client very well. So.
So, from there, I mean, we have already covered most of the questions. One more question is there. I'll come back to you.
But before that, as ma'am, that you have now touched upon a point in which that how the lawyers will have to guide their clients regarding all these things. I just do have one maybe a concern, apprehension, or maybe a layman understand or a law teacher perspective, whatever it is. Don't you believe that the lawyers who is having all this that loopholes, finding out loopholes, and wherever law lacks, that will be an opportunity for my client kind of concept that lawyers do have. That itself gives a lot of freedom and the courage that if I do have money, I can buy that lawyer, then I can do whatever I want to do with my company kind of attitude. In which, I mean, that is there in India. I have seen it with people, and I do believe it so. And in that area, how far the lawyers can contribute to bring the culture, that culture of obedience, as he told, that system in place, and balancing their business strength and their the money that is always there. Business is for making money, that I can understand, and that everybody can understand, and that is acceptable. But that bringing the culture of obedience and going in accordance with law, what role lawyers do play, I mean, can play, or maybe they are not doing it now. All the youngsters who is sitting over here, that I just want to hear that what are values and ethics and this thing can lawyers can bring into that area while they are their client interactions and all, so that these people can hear and think about it. It's not a profession only for money, but building up culture, building things in place, and bringing law in place. That's also our job. That
See, while migration from MRTP Act and Competition Act, just a little bit of a background. Initially, like some earning money itself were looked upon like there's something wrong. Somebody who's earning huge money. That was a MRTP concept. Later on, with the economy opening up, then came this competition law, which encouraged competition. It's just as Manmohan in some last program I heard he said very rightly that if somebody is earning great money, you shouldn't be skeptical that there is something wrong. I mean, he's contributing to the economy of this country. So that concept that somebody is earning money is by wrongful means is always not true. Maybe there are some instances here and there which is everywhere. I mean, but this generic concept has to go firstly. You can earn money being within the legal framework. It's not that legally you can't earn money. For the business houses also, there are big industrial houses, I won't name them here, which are very, very compliant, and they are very particular about all sorts of compliances. There are quite a few which are Indian multinationals also. So it's not that by merely somebody earning money and he's focusing on earning money. As I said, that it is better to be compliant and then focus in your business, because if you are entangled into litigation, then you can't devote that effort, energy and time to your business. So for the lawyers, I would say it's better to give a fair idea, and I mean, being absolutely inside the court premises all the time. There are instances here and there, but by far, I would say that judiciary is still one of those institutions which has preserved its integrity. I mean, whatever we see in media coming from here and there, there may be isolated instances, but I have seen very good judges and very thorough knowledge, and be it a senior counsel or at the other side was a junior counsel who was opposing, but still the focus was on the merits of the case. So therefore, don't give a false hope to your clients. I would say that that oh, this will be done, this can be handled, which is not, because if you give this, then your client is not going to leave you. Even after the matter, he'll come and ask, "Madam, stay क्यों नहीं मिला? हम कहाँ हमारी ये रह गई थी, you know, we face this every day. So it's better to tell him we'll try, but then it's difficult, you know, if you get it, it's your good luck. So that fair outcome, which we can, like putting in 25 years in this profession, we have a fair idea in which direction this case will go. So that fair idea will have to be given, because if you give what you said, that the lawyers say that they can manage this and that, but it really doesn't happen in most of the cases. And then their client falls back on you and says, "Oh, you assured me, but it didn't happen." So it's better to be fair, I would say. And you have the client in the long run. That's my experience. I'm a first generation lawyer. Let me tell you this as well. And I don't belong to Delhi. I came to Delhi in 1999, started my practice. And then, you know, there were encouraging and discouraging statements also. So people said, well, what would you do? But I always wanted to come to Supreme Court, become an AOR. That was my dream. And then, you know, I have found that while I give a very fair idea of the outcome to my client, they come back and say, if one client sends me 10 clients, they say, please go to her. She will tell you fairly what is going to happen. And thereafter, it's your decision whether you want to go ahead with the case or not. So therefore, I mean, in the long run, it pays. That's what is my
If I may just
experience.
add one point to what Ms. Bhattacharya is saying, is that, you know, like you have Google doctors, you have Google lawyers. So your
That's
clients
a
are
problem.
very,
Yeah.
very aware of what there is, and there's technology at the other end that you're using. So you've got to justify how much of your own application of mind you've done, because there's independent original thinking, and how much of technology you used. And yeah, they've already searched the net for whatever their problem statement is. So you really should know what you're talking about.
I mean, as a teacher also, we are facing the same problem. That is, once earlier, whatever.
Misinformation is circulating. I mean, that's quite damaging for these kids, I would say, because they are more into, I've seen this generation, technology driven. More than us, they would listen to technology.
So I still remember that in National Law School background, people used to come with their laptops and sitting in the class, and whenever we are telling something, they'll bring the latest judgment. So I used to spend days to go to class because I should know everything that is available in the platform, and I'll have to create questions in such a way that that is not available in Google. That kind of try we need nowadays if we want to really tackle the students also. We are facing the same issue. That's why I told you, this younger generation is really, they are creative. I think we are actually, you guys will have to leave, because the traffic, I know that going back will be more than that. We've come over here. So one question I don't want to leave that question. That is why, that is the intersectional integrity. That is different sections. She told that to Gautam, that is you were telling that you are a person who doesn't know anything about the competition law, or there may be people who are too good in technology and law. One person is in competition law. Every intersections, once it comes, once there is an integration, the things will be easy. So what kind of integration can bring a better governance strategy and a landscape of policy that can bring good results?
So ma'am, let's look at AI, and let's look at the regulators which get involved. One, of course, is Competition Commission of India. You have Digital Communication Commission. You have TRAI. You have Department of Telecom. You have Controller General of Patents. He'll also be looking at all the data and all, seeing how it is being used, and maybe a couple of others.
Financial regulation.
Yes.
RBI, SEBI, IRDA.
There is whole plethora of regulators who get involved while trying to look at this new issue, AI, which is coming up. And of course, the data privacy as well, which is coming up. Unfortunately, in India, the moment you have multiple regulators looking at a problem, they start fighting over jurisdiction. They are not looking at what is the best outcome for Indian market, Indian economy, Indian people. They are looking at their own jurisdiction. I'll give you an example. In the Competition Act, there is a provision, Section 21 and Section 21A, by which Competition Commission of India can make reference to other regulators if there is an issue pertaining to their sector. Similarly, under 21A, other regulators can make a reference to Competition Commission of India. Because if they're assessing an issue and there is a competition element involved, they can ask Commission for its own views. CCI started sending those references in the beginning, only to realize they were not getting any responses. In this scenario, it's very harmful for the economy if we are not learning from each other. I can cite two cases where this has come up. One is the telecom industry case, where Bombay High Court and even Supreme Court went to Supreme Court, and Supreme Court said that look, this is an issue of interconnection points, point of interconnection, POIs. Let TRAI first decide, and then maybe CCI can interfere. And that matter is now gone because the issue is before TRAI itself. They're still trying to lay down the laws regarding it. So CCI is out of the picture. Recently, Supreme Court has decided if it is an issue of patents, then CCI should not exercise jurisdiction. What we need to understand is there are sectoral regulators and there are cross-sectoral regulators. And they both need to work in tandem for the best outcome. So what is the way ahead? I suggest that regulators need to talk to each other. It may be a good idea for officers of different regulators to get posted with different regulatory authorities so they can learn from each other's experiences. And then that learning has to now translate into lessons for Indian courts. Because end of the day, it will land up either in a High Court or a Supreme Court, and if the judge sitting there is not informed about these issues, you will end up with a judgment which will lay down the law lasting next 5 to 7 years because it takes a long time to change the Supreme Court judgment. And that can really damage the economy. So sharing of human resources, learning from each other's different sectors, and then judges need to be informed.
Because otherwise they seem adversarial, it should not be.
Yes, they should be working tandem.
Because they are adversarial, the problem is like.
Just adding on to what the every day in courts we see this adversarial attitude between the departments, so it becomes a major problem because if we work in tandem, they don't see it as a whole. Inclusivity is not there. They want to be like exclusives.
Thank you, three of you, that I am not giving you a 1 minute conclusion part because the time is up already. And I know that you might be having some questions. Unfortunately, we don't have time for taking students' questions, but we can do one thing. Write down all the questions, mail it to us, we will mail it to them, they will give the answers, and I'll make sure that they are getting their answers from experts.
We will give all the answers to the questions you sent us.
Yeah, please. That's a promise because this is a working day, and they do have work commitments also, and out of which giving back to the society is the process that is happening over here. I'm so thankful for that. As the moderator, I can say that if there is one takeaway from today is that compliance need not be a scary word. It can be the art of doing the right thing, and before the regulator finds out, you didn't. True. And another thing that I do have a takeaway is that interconnections and that sectorial connections and connect together, that talk together, have dialogues, you just have a consensus. Nothing is there which cannot be resolved through a good mediation. That's what I do believe. Yeah, there should be. And thank you all. It was a very, very big thing to our intellect and the way that we do things. Yeah, the thing
Totally our pleasure. Your young energies always excites me, and obviously, thank you for bringing that energy back for us to learn.
Thank you so much.
Thank you so much to all the esteemed panelists for sharing your valuable insights today. The discussions today have highlighted the importance of the proactive regulation and the collaborative enforcement to address the emerging issues related to the market transparency. Thank you once again to our esteemed panelists for your thoughtful participation. We are truly honored to have you amongst us. Thank you so much.
So let's have a group picture. Yes.
All are requested to kindly stand up on the stage. The faculties to kindly come over here for the group photograph. Thank you so much.
Faculties in the coordinators, please come. Here, come. Yeah, come, faculty. Ma'am. Over here, ma'am. Yeah, please. Over. Where is our pupil?
Ready?
Okay, come. Where? We'll have to turn for the students. So if yeah, we'll have to turn there. Where is the Thank you, students. Big shout out to all of you.
थैंक यू मैम यार इन लोगों को तो भी गजल के बाद होने दो देश के बाद
I request all the students to be kindly seated. I request the students to be kindly seated. The chief guest is arriving shortly for the inaugural ceremony of the first international conference. I request everybody, all the students to be kindly seated.
अरे गए
we have lecture you will get the attendance
I request the students to be kindly seated. The faculties are requested to please ask the students to sit on their respective seats.
Guys, that job bus within 5-10 minutes is reaching. उसके बाद session over then you can leave. Okay. Better. 10:54 हो गया. तो वैसे भी लेकर
The attendance of the students will also be marked for this session. So you are all requested to kindly be seated on your respective seats.
बाहर जा रहे सारे आइडेंटिफाई करते 5 मिनट में वापस नहीं आएंगे।
कहाँ है कोई कुछ तो वो तो पीछे भी पड़ी है देख क्या हुआ है हाँ वो अच्छा चलिए भाई हो रही
Kindly be seated. All the students, please be seated. The chief guest is about to reach.
गेट लगा गेट पकड़ ले ऐसे वेट मत कर
बंद कर दो चल ले
That is what you are doing
कॉल आ रही है किसी ले किवाड़ बंद हो गए ले
रिलेशन हम हटा देंगे, चिंता मत करो, जाने दो।
कोई क्लास नहीं है, इधर आके बैठने हैं 5 मिनट के अंदर।
एक बजे खत्म होएगी।
ले लेते कौन अर्शिता